This video addresses social media and how it interacts with the Minnesota Data Practices Act and open meeting law. Chapter 13 of Minnesota statutes contains the Minnesota Government Data Practices Act, while Chapter 13D contains Minnesota's open meeting law. Government, appointed board member, and elected official use of social media can lead to an array of questions, including whether corresponding data are government data, whether certain actions on social media violate the open meeting law, and whether blocking members of the public from these accounts is permitted. Before we take a look at how the Data Practices Act and open meeting law apply, it is important to note that there are other laws and constitutional arguments in some of these situations that our office does not address. We will note these out-of-scope issues throughout this presentation. Some First Amendment arguments are currently being heard by courts across the country and will not be discussed in this video, including arguments relating to whether government entities or elected officials may block members of the public from their social media accounts. The Data Practices Act does not specifically address social media accounts or classify social media account data. However, the general definition of government data encompasses any potential social media account information that falls within that definition. So long as the social media account data are collected, created, received, maintained, or disseminated by any government entity, then the data are considered government data. The Data Practices Office assists the Commissioner of Administration with her authority to issue advisory opinions. There is one recent opinion that addresses social media and the Data Practices Act. In Advisory Opinion 19-001, a city asked whether it responded appropriately to a data request for information from a Facebook page maintained by the mayor, expressing its personal views when it replied to the requester that the information was not government data. The Commissioner opined that the city responded appropriately because the mayor created and maintained the page outside of his official duties, and the city did not collect, create, receive, maintain, or disseminate that information. Specifically, the Facebook page was not created in the course of the mayor's city-sanctioned responsibilities and did not represent the city's official position on issues. Thus, the information did not fit within the definition of government data. It's important to note that this advisory opinion is non-binding and also specific to the facts presented to the Commissioner. If there were additional facts showing that the city was endorsing the mayor's social media activity, it was related to the official business of the city, or if employees of the city drafted posts or content, there may be a stronger argument that the social media data was government data. Additionally, any First Amendment issues are out of scope in this presentation. To work through whether social media data are government data, we will work through two examples. First, a government employee posts on her personal Twitter account about a recent policy decision. Are her tweets government data? Probably not. If the individual is acting outside of her official duties or job description, her tweets are probably not government data. This analysis will depend on the facts specific to each situation. Again, any First Amendment issues are out of scope in this presentation. Next question. If a city clerk posts on the city's official Twitter account about a new city policy, is this tweet government data? Yes, probably. Not only is the content of the tweet related to the city clerk's official duties, but it is also posted on the city's official Twitter account. There will be plenty of gray areas between the two scenarios we discussed. If you have any questions, please contact our office and we would be happy to discuss your particular situation further. The open meeting law only addresses social media in Minnesota Statute Section 13D.065. Generally, members of a public body may use social media as long as the exchanges are with the public. However, public body members should refrain from engaging in discussions about official business over social media that include a quorum or more of public body members. The Minnesota Supreme Court has yet to issue a decision relating to this statute section, so the official guidance on social media and the open meeting law is limited. Thank you for viewing this video. This was only a brief overview of how social media interacts with the Minnesota Government Data Practices Act and the open meeting law. Again, there are other rights that may be impacted by government social media use, and this video does not address any First Amendment implications. If you are interested in learning more about the Minnesota Data Practices Act and open meeting law, please visit our website.